While many of us have schedules that are, slightly slower right now, Sean, it is a perfect time to take advantage of this opportunity to do those things on your list you've always meant to do. Estate planning. Maybe you want to create a trust with your spouse. It's something you've been talking about for years and you haven't done it. Well, the attorneys at Jeffrey Burr can lead you through that and perhaps clue you into a few things that are unique in the state of Nevada.
Absolutely. Here to protect our assets is Rebecca Haynes. She is the attorney with Jeffrey Burr Limited. She's also a estate planning trust litigation there as well. It's great to have you. How are you?
Hi.
Thank you.
Let's
Very
talk.
well.
Let's talk about what a living trust is. First of all, for those who don't know, how does it help not only protect you, but protect your assets from creditors, or maybe, like, heaven forbid, somebody trips at your house and they decide to sue you for the most frivolous lawsuit ever. They try to take you for everything you have. Will that protect you there as well?
So, unfortunately, a revocable living trust doesn't provide that kind of creditor protection.
Okay.
While a living trust or revocable trust is an excellent estate planning tool for incapacity planning and probate avoidance, it doesn't provide creditor protection. But in Nevada, there are some other kinds of trusts that do.
Those are the ones I
Very
trust.
interesting.
Yes.
Yeah, those are the ones to trust. See, this is so interesting because I would have thought it was just, it's kind of one trust fits all, but that's not the case. So they're different ones. And so which are unique to the state of Nevada?
One of the primary ones, it's called an asset protection trust or self-settled spendthrift trust, domestic asset protection trust. There's all sorts of names, but this kind of trust does provide that creditor protection. And Nevada is one of 18 jurisdictions that allows the creation of this kind of trust. And this trust, as it is named, provides protection for someone against those frivolous lawsuits. I mean, unfortunately, we live in such a litigious society. You never know, car accident, having a pool, anything like that. But this trust, allows a person to create it, put assets in it, retain beneficial enjoyment of those assets, have a certain amount of control. But then after a seasoning period, anything that's in that trust would be protected. And there are certain formalities that are required to get that kind of protection, which make it a little bit different than a living trust. But it is a part of a comprehensive plan, that works together to accomplish, in addition to incapacity planning and probate avoidance, that asset protection just to prevent, anything from happening.
Well, let's throw a for instance out there. Let's say a parent has a kid living at home. The kid's old enough to drive, throws in the keys, says, all right, go ahead, do your thing. Kid gets in an accident. Are the parents liable for any of the damages beyond insurance? Can they be sued for what the kid did in their car?
So for a minor child, yes, they can. For an adult child, though, unfortunately, again, if a parent has that car registered in their name and the kid is driving it, gets into an accident, any kind of damages exceed the insurance coverage on that vehicle, that person can come after the parents to satisfy that judgment. And so what you can do, though, just as an option, is that once a child turns 18, you can, or a parent can transfer title to that vehicle to the child's name. But to prevent that child from trying to transfer it or sell it without the parent knowing, the parent can stay on as a lien holder. And so you kind of get the best of both worlds, where the parent wouldn't be liable for any kind of damage, but they're still giving their child a car.
Gotcha.
Very interesting. No, it's a real situation, and kids are kind of in that zone between, being a minor and being out on their own. With every new administration, I think there are some new things to know about. Anything we should know in terms of updating our estate plan with the new Biden administration?
So estate planning wise, President Biden did propose a reduction to the current estate tax exemption amount. Right now, that amount is $11.7 million per person. And his proposal was to reduce that to what could be $3.5 million a person. Mm-hmm. And so what that means is that if that legislation gets passed, that someone who has assets over $3.5 million when they pass away, up to half of that would have to be paid in tax to the U.S. Treasury right away. And so there are things that can be done now to help mitigate that. And so right now is a good time, like you said at the beginning, to just talk to your estate planning attorney about options that might be available, if you are at that level.
Gotcha. It's great having you. Thank you so much for joining us.
Thank you.
Thank you for having me.
All right, listen, if you want to start getting your ducks in a row, make sure that the assets that you've worked so hard to build are protected. Reach out to jeffreyburr.com or call the number you see right there on your screen, 702-433-4455. They're on Paseo Verde Parkway, and Jeffrey Burr Limited, a proud sponsor of the Morning Blind.